All right. Well, good morning, everyone. Thank you so much for joining us this morning. We're glad to be able to talk to you about this important issue. Our plan today is kind of discuss an overview of Title IX, what are the proposed changes, what prompted them, and what's the status right now. And then we'll talk a little bit about what we expect to see once these proposed regulations are final, and a little bit of an overview of what the legal landscape is. So we'll present for about 40 minutes. We'll have a Q&A at the end. You can feel free to enter questions at any time in the Q&A function, not the chat. And then I also have here our email addresses. So feel free to jot those down if you have questions throughout our presentation, or later on, you can always contact us directly. So my name is Cory Brewer. I'm one of the attorneys here at Will. I focus solely on K through 12 education on both the litigation team and policy team. And I'll be presenting today with my colleague, Luke Berg. Luke is also an attorney. He's deputy counsel here at Will, and he is on our litigation team. For those of you not familiar with our organization, and I'll kind of continue with the introduction here as individuals continue to join, that way, hopefully they don't miss any of the substance. But those who aren't familiar with our organization, WILL, or the Wisconsin Institute for Law and Liberty, we're a nonprofit organization. We're a law and policy center. We're based here in Milwaukee, and our work is really dedicated to kind of limited government, free speech, transparency, education reform, and really Title IX falls into several different categories of what we're able to do here at Will. So an overview of Title IX, just briefly, the full title here is Title IX of the Education Amendments of 1972. So this federal law is now over 50 years old. As of last week, it's now 51 years old. And what it does is it prohibits discrimination on the basis of sex. It is part of the United States Code. So it's a federal law enacted by Congress, so by the legislative branch. And then the Department of Education, so part of the executive branch, promulgates rules through a rulemaking process to implement that federal law. The law itself is not changing. What we'll talk about today are some proposed changes to the regulations by the Department of Education. And it applies when a recipient participates in any education program or activity that receives federal financial assistance. Now, back in 2020, the United States Supreme Court issued a decision in a case called Bostick versus Clayton County. And in that case, and this is important to kind of understand how we got to where we are. In that case, the court determined that under Title VII, which pertains to employment discrimination, Title VII could be interpreted to mean that an employer cannot fire someone because of their sexual orientation or gender identity. Following that decision, in the employment context, President Biden issued an executive order directing federal agencies to interpret Bostick to apply to any similar federal laws that prohibit sex discrimination. So following that executive order, then the United States Department of Education began the process of issuing new regulations or proposed regulations for Title IX. And just as a real high level overview here, in terms of what are the most significant changes that we expect to see, there's two sets of proposed regulations that have been issued. The first is kind of the general proposed rules or the non-athletics proposed rules. And the biggest changes we expect to see there, based on what the department has published, are a redefinition of sex discrimination or an expansion of sex discrimination to include discrimination on the basis of gender identity, including other categories, and a change in due process rights. And then in the athletics context, which Luke will speak more about, we expect to see a limitation on schools' discretion to control athletics participation based on students' biological sex. So what is the status right now? These proposed regulations are just that. They're proposed, they're not yet final. That means they do not yet have the force of law. The Department of Education is in the process of reviewing hundreds of thousands of public comments. They're required to review them all. Initially, the rule was going to be published in May of 2023, at least a final rule for that first kind of general set of proposed regs. And obviously it's June now and we don't have a final rule yet. So the department had come out and they said, we're still reviewing these public comments. We expect to issue a final rule for both the athletics and non-athletics regulations in October of 2023. And then, once those rules are final, we expect to see a lot of litigation, both challenging the process by which these rules are going to be implemented and also just the substance of the rules themselves. Now, turning back to that kind of first big change that I said we expect to see. Right now, the regulations prohibit discrimination on the basis of sex. And we expect to see that definition expanded to include discrimination on the basis of sex stereotypes, pregnancy, sexual orientation, and gender identity. Now, interestingly, Title IX, the federal law itself, explicitly allows for sex discrimination in some contexts. And an example of that would be father-son and mother-daughter events in schools. And the Title IX regulations also allow for sex discrimination in some contexts. Examples might be housing, dorms, bathrooms, and locker rooms. So what is currently in the federal regulations is here on the left side of the screen. A recipient, so a school, may provide separate toilet, locker room, and shower facilities on the basis of sex, but such facilities provided for students of one sex shall be comparable to such facilities provided for students of the other sex. And what we expect to see here is not having that be repealed or removed. That will still be there, but it must be interpreted to mean that schools, educational institutions have to allow access based on asserted gender identity at any given time. So in applying this part of the regulations, schools would have to do so in the context of students' gender identity. And just a reminder that the text of the federal law states no person in the US shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program receiving federal financial assistance. So an argument could be made, and we expect to see litigation indicating that these new proposed rules might conflict with the text of the federal law. And just briefly, a lot of folks are also following changes to due process. If you remember in 2020, these changes were just made in 2020. So a lot of individuals are asking, well, why do we need to change the due process rights again? They were just revised. And some of the things that we expect to see change are a change in the evidentiary standard from clear and convincing evidence to a preponderance of the evidence. Right now, accused students, so students accused of sexual harassment, have a right to cross-examine witnesses against them. That would be removed. Right now, the same person cannot investigate and adjudicate these kind of disputes or claims, and that would be removed. And just kind of right off the bat, that raises multiple questions, one of them being bias, potentially, if the investigator is also the decision maker. And then another potential for just more errors to possibly be made if it's the same person in both roles. Last, the change would abandon the definition of harassment, which closely mirrors United States Supreme Court case law. It kind of changes it from a objective standard to a standard that's objective and subjective. So specifically right now, sexual harassment is defined in the regulations as conduct on the basis of sex that is severe, pervasive, and objectively offensive as determined by a reasonable person. That would be changed to include unwelcome sex-based conduct that is based on the totality of the circumstances and evaluated subjectively and objectively. So that would be a big change as well in terms of what qualifies as sexual harassment. And then last, before I turn it over to my colleague Luke, pronouns. We receive a lot of questions about what these proposed regulations might mean in terms of pronoun use in schools. A big issue in the space is whether parents should be notified or have the right to consent before their child changes their name or pronouns in school. Will has a number of cases on this topic. There's a lot of cases all over the country on this topic of parental notification, parental consent. But with regard to Title IX and these proposed regulations, it's not as clear how they would apply to that parental notification and consent aspect. It doesn't directly address it. It doesn't directly address what teachers should do if parents disagree with how a child wants to be referred. It's possible that the Office of Civil Rights within the Department of Education could interpret the proposed rule to mean that it is sexual harassment to not use an individual's preferred pronouns under the rule. And if that is the case, if there are students essentially effectively being compelled to use one another's preferred pronouns, then I think that would raise a lot of First Amendment compelled speech concerns. And that would be another area that we would expect to see litigation once these rules are final. So with that, I will turn it over to my colleague, Attorney Luke Berg.
Well, hi, everyone. Thanks for joining. Just give me a second to get my screen up. So I'm going to be talking a little bit about the bathroom issue again, and just some of the litigation, the current status of the litigation around that issue. And then I'm also going to talk about the new athletics rule. So there actually has been a fair amount of litigation around the country on the bathroom issue already under the current Title IX rule. And you would think this would be a fairly easy question, given the text of the current rule that says explicitly that schools can provide separate facilities on the basis of sex. But notwithstanding that clear language in the text of Title IX, some courts have held that it violates Title IX under the current rule, not the new rule, not to allow a student to use the facilities that correspond to their asserted gender identity rather than their sex. Now, courts have gone different directions. So there is a dispute among the court system around the country right now. The most notable three cases are from the 7th Circuit, the 4th Circuit, and the 11th Circuit. For anybody who's not familiar with the federal court system, at the appellate level, the country is divided into 12 circuits, each of which covers various states, and any precedent from one of those circuits is binding on cases in those states. So most notably, the 7th Circuit, which covers Wisconsin, Illinois, and Indiana, in a case called Whitaker against the Kenosha School District, held that it violated Title IX for the school district not to allow a student to use the bathroom associated with their gender identity. And these courts, the 7th Circuit and the 4th Circuit, have tried a variety of different theories to get around the clear text of the regulation. So I've included a quote from the 7th Circuit opinion. That's kind of the key quote from the case. The 7th Circuit's theory was one of sex stereotyping. This is a theory borrowed from employment discrimination cases. And the idea is that policies punish students, quote unquote, for nonconformance with gender identity. The 4th Circuit, which came to the same outcome, but had an entirely different theory. Their theory was that it is inherently discriminatory to rely on its own definition of sex rather than the student's definition of sex. Other courts have rejected both of these arguments, both district courts and federal court. And most notably, the 11th Circuit held that it doesn't violate Title IX to have bathrooms and relied on the straightforward text of Title IX. So here's the case from the 11th Circuit. It's called Adams. It was the most recent one. It was decided just last year. And the court relied on the simple premise that the clear text of Title IX and the regulations, under the text, the word sex means biological sex. And because of that, schools are allowed to have facilities limited based on biological sex. Now, the 11th Circuit case is probably the most significant of the three, because this one was decided en banc, which means that every judge in the circuit considered the question, and the majority of the judges held that it doesn't violate Title IX to have bathrooms limited by biological sex. So in legal circles, this is what we call a split among the circuits. The circuits have disagreed on the question of whether limiting bathrooms based on biological sex violates Title IX. And when there's a split, that usually means that the Supreme Court will get involved in the case to resolve the issue. But the Whitaker and the Grimm cases, those are completely over and done, so that those cases are not going to get to the Supreme Court. And the plaintiff who lost in the 11th Circuit case decided not to file a cert petition. The time is run on that. So none of these cases is going to get to the Supreme Court. So for the Supreme Court to take a case and resolve this split, it would have to be another case that would come along, and there's a number of them winding their way through the court system, but it could be a little while before it gets to the Supreme Court. Now, the reason I covered the background on all of this is that because the new rule, in our view, at least as we read it, is so clear that schools must allow students to use whatever facilities match their gender identity rather than their biological sex, this bathroom issue is likely going to be resolved in litigation over that new rule. And as we said, the new rule that's proposed is most likely going to be finalized in October, and you can expect that there will be a pretty quick flood of litigation to challenge the rule. And I expect that a lot of the litigation will revolve around the bathroom issue in particular. So if that litigation loses and the rule is ultimately upheld, then it will be very clear schools will be required under Title IX to allow students to use bathrooms and locker rooms in accordance with their gender identity, asserted gender identity, rather than with their sex. If the rule is struck down, it could resolve the bathroom issue, but it could also be struck down in a variety of other theories. It's going to depend on the rationale. So for any school board members or administrators who are listening to this call, you just need to pay attention to both of these lines of cases, both the existing litigation under the current Title IX rule and the new litigation challenging the new rule as it comes out, because both of those could say a lot about the bathroom issue and could ultimately resolve it. But for the time being, the main precedent that applies to Wisconsin is Whitaker. And in any case that's litigated on the subject in Wisconsin, Indiana, or Illinois, that is going to be the first case that gets cited by the other side. Now, in our view, Whitaker does not necessarily dictate the outcome of this issue for a variety of reasons. And I'm just going to go through a number of those, but there are more than I'll be able to cover during the call today. So Whitaker was decided in a preliminary injunction posture. So ordinarily a case goes through a lengthy process to reach a final judgment. Both sides present evidence, can gather evidence from the other side. But sometimes parties, if they believe they need a decision quickly, can move for a preliminary injunction. And that's what the parties did in Whitaker. And that's the posture in which the case went up on appeal to the 7th Circuit. So this was not a final decision on the merits, preliminary decision based on arguments and evidence that were presented at a very early stage of the litigation. And then the case ultimately settled before it was resolved and reached a final decision on the merits. And in the process of its decision, the court relied heavily on the particular evidence and arguments that the lawyers had provided in the case. So if a school district were challenged in a separate case and provided different evidence and different arguments, the outcome could be different. The 7th Circuit has also since recognized that Whitaker applied the wrong standard for an injunction. It has said so explicitly in a case after Whitaker. Whitaker was also decided before Bostick, the case that Cory talked about earlier, which undermines the rationale somewhat. So Bostick relied on a similar theory as Whitaker, but the Supreme Court in Bostick specifically said that its ruling and rationale wouldn't necessarily apply to Title IX. It carved that out for future resolution. So I think that undermines the rationale of the 7th Circuit case somewhat. Whitaker's also been undermined by the 11th Circuit case, which more thorough, and as I mentioned, was en banc, so considered by all the judges in the 11th Circuit. Whitaker only involved bathrooms, didn't involve locker rooms. There are obviously different privacy concerns in locker rooms than there are in bathrooms, so that's another ground that it could be distinguished on. And then in Whitaker, there was evidence that there wasn't a good neutral alternative. So the bathroom that the school district offered to the student was all the way across the school and didn't allow the student time to get back to their classes. So if a school district had a neutral third alternative that transgender students could use, and that it was a reasonable alternative, that again could tip the difference. So these are just a few of the reasons why Whitaker might not dictate the outcome in a future case. But all of that stuff will have to be litigated eventually, and there are currently a couple cases in the 7th Circuit from the Southern District of Indiana where these nuances and issues are being litigated. So it's going to come before the 7th Circuit in the near future, and so you need to pay attention to that litigation and the litigation over the new rule. So from there, I'm going to turn to the new athletics rule. So as Cory mentioned, there are two rules pending. One is sort of the main Title IX change. That's the one she talked about. And then they have a second rule that focuses entirely on athletics. So I'm just going to give you kind of an overview of the current state of Title IX. So the current athletics rule has been in place since 1975. Shortly after Title IX was adopted. And it does three main things. The first thing it does is it provides a general rule that prohibits sex discrimination in athletics. But there's an exception, a major exception for sex-limited sports teams. So it allows for sports teams to be sex segregated in competitive sports and contact sports. That's what I have up on the slide here is the text of the main exception. And the contact sports that are listed are the ones you'd imagine: football, basketball, hockey, boxing, wrestling, and rugby. The rule also says that if there is no women's team in a particular sport, women must be allowed to try out for the men's team unless it's a contact sport. But this is a one-way rule. It only applies in one direction. It doesn't require it doesn't allow men to try out for women's teams. It only allows women to try out for men's teams. And the point of that is that the well-recognized purpose of Title IX was to provide more opportunities for women in sports. And then the third and final component of the existing rule is an overall equal opportunity requirement for athletics overall. So school doesn't necessarily have to have the exact same sports for each gender, but overall the athletic opportunities have to be equal. So that's kind of the high level framework. Here's what the new rule does. The new rule is very short. I know it doesn't look short, it looks like a lot of text, but in terms of regulations, this is actually pretty short. So it says, if a recipient adopts or applies sex-related criteria that would limit or deny a student's eligibility to participate on a male or female team consistent with their gender identity. So if you have a rule that requires athletes to play on a team in accordance with their biological sex, then the criteria you use have to, for each sport, level of competition, and greater education level, be substantially related to the achievement of an important educational objective, and two, minimize harms to students whose participate on a male or female team consistent with their gender identity would be limited or denied. So I just want you to notice what this doesn't do. It doesn't say anything clear about when schools can and can't limit sports participation based on sex. It creates a test to be applied, a balancing test to every situation, and indicates that that test would apply differently for each sport, level of competition, and greater education level, but it's a test. Now, this test to lawyers and courts is pretty familiar. It's called intermediate scrutiny, is what we as lawyers call it. It's the test that courts apply generally to claims of sex discrimination. It's not insurmountable, but it is a very high bar, and it will require schools to mount evidence and arguments to defend any requirement that they have limiting sports based on biological sex. this rule would give the department a lot of power. What's allowed and what's not. And if these issues ever get to litigation, it's effectively an attempt to tip the litigation against those who believe that women's sports should be limited to biological women. Now, although the text of the regulation itself is very clear and provides this balancing test that's very hard to know how it would come out in any given situation, in the preamble of the rule, which is just the introductory text of the rule, the department provides a bit more guidance about how it thinks this rule would apply to various examples. And before I get to what it says, I just want to make some initial comments about it. So the first point to know is that the preamble text, this introductory text, is not the law. Courts typically don't give nearly as much weight to an agency's preamble as they do to the text of the regulation itself. So it's very possible that if the proposed rule becomes final as it's written proposed, that courts will disagree with the department's interpretation about how this test would come out, even applying the very same test. So just to give you an example, West Virginia District Court recently held that limiting sports based on biological sex does meet intermediate scrutiny, this exact test. And as you'll see in a moment, the department thinks that a variety of situations wouldn't meet this test, but courts have already held that it does in slightly different contexts. But this guidance that I'm about to cover is how the current administration will apply this test to these various examples. So if a school district is subject to an enforcement action, this is the position that the Department of Education will likely take, assuming that it finalizes the rule as proposed. And because of that, schools risk the cost of having to deal with an enforcement action and the federal government attempting to take their funding away if they don't follow the district's guidance. So bottom line, it's going to take a lot of litigation before anything becomes clear, given the way that the rule is written and given that it's this very indeterminate balancing test. So let me turn to what the guidance says. So the first step, read part one again, any rule limiting sports based on biological sex has to be substantially related to the achievement of an important educational objective. Okay, so what is an important educational objective? What counts? So the department's guidance lists two things that it believes would count as an important educational objective to limit sports based on biological sex, and that's fairness in competition and the prevention of sports-related injuries. It says these are two objectives that you can rely on to have such a rule. What doesn't count, and it lists a number of things that don't count. The first four all are about communicating disapproval of a student's gender identity, excluding all transgender students from sports, passing a rule that solely pretexts for singling out transgender students, or requiring conformity to sex stereotypes. These are four things that the department says wouldn't count as a good reason to limit sports based on biological sex. And I just want you to notice these four things that the department says are not allowed are not typically things that anyone would ever invoke for purposes of one of these rules. Nobody would justify a rule limiting track, for example, based on biological sex by saying, well, we really just want to exclude transgender students from sports. That's not the point. The point is competition and preventing injuries. So it at first may seem a little odd to put these in the text of the rule, but I'll come back to why I think these are in here. But mixed into the middle of these four, which I think most people would agree are illegitimate reasons for having limiting sports based on biological sex, the department throws in a fifth thing that schools can't rely on, and that is administrative convenience. And this one is really significant because every single rule is based on this. That's exactly why you have a rule. You have a rule for administrative convenience rather than considering each situation on a case-by-case basis. So when the department says you cannot rely on administrative convenience, it's going to make it very difficult for school districts to defend any rule limiting any sport based on biological sex. And I'm going to come back to this one in a little bit. So the next aspect of the test is that the rule has to be substantially related to these two objectives, fairness in competition or prevention of sports-related injury. So what does it mean to be substantially related to those? So the rule emphasizes that schools and colleges have to consider every sport, level of competition, and grade or education level differently. And because of that, the department, and this is really where it gets the meat of its guidance, says that in its view, this means a few things. So the first thing it means is that schools and colleges can't have an overall rule across all grades, competition levels, requiring athletes to participate in sports according to their biological sex. So no categorical overarching rules according to the department. Second, the department says that at the elementary and middle school levels, it thinks that it's very unlikely that there would ever be good reasons to limit sport based on biological sex. Why? The department says, well, at the elementary and middle school levels, competition isn't as important and there's less risk of injury because it's not as high level of competition. And so therefore it thinks you will almost never be able to have such a rule at the elementary and middle school levels. But think about whether that's actually true. Risk of injury might actually be higher at elementary and middle school levels because bodies are smaller, athletes are not as refined and well trained physically, and so there might be more likelihood of injury at those levels. And competition still matters a lot at the elementary and middle school levels. Competition can be exactly what motivates a young person to work hard enough to compete in high school and college. So it, again, this is the department's view of how this would come out, but the text of the rule only provides this high level test. And so it's going to have to be litigated. If this is how the rule is finalized, it's going to have to be litigated, and it remains to be seen whether courts will agree with the department's guidance at the elementary and middle school. The next thing the department says is for low competition sports, so intramural teams, no cut teams, etc. Again, it thinks very unlikely that that a school will be able to justify such a rule because, again, in the department's view, competition and risk of injury are not as significant of factors there. Again, not clear that that's true, but that is the department's view. So the areas in which the department thinks that such a rule might be permissible are mostly high school, high-level competition, so the varsity team, varsity sports, and intercollegiate athletics. But even in those contexts, the department says that you can't apply any generalizations about the capacities of biologically male and female athletes. So what does that mean? I don't have any idea, and the department doesn't provide a lot of guidance here. It just says broadly that you can't rely on generalizations, but of course, the problem with that, and this is the same point with respect to the point that you can't rely on administrative convenience, is that every rule relies on some sort of generalization, right? A rule that track and field at the varsity level requires athletes to participate based on biological sex would be based on the sort of common sense, obvious notion that men generally at the highest levels will be able to outperform women and will shut them out of competition at that level. But of course, there are always exceptions to that rule, to that generalization. So that is a generalization. So if you can't rely on generalizations, it's going to make it very difficult for schools to justify any rule. The other thing that the department says in its guidance is that if we can come up with any other way, we the department after the fact can come up with any other way to mitigate the possibility for injury and preserve competition, then we will assume that your reason for adopting a rule limiting the sport to biological sex is pretext for one of those 4 prohibited justifications that I mentioned earlier. So this effectively gives the department an enormous amount of to decide on a case-by-case basis what's allowed and what's not, and to second guess school decisions about this. So could a school, for example, have a rule for all high school sports? It's totally unclear. The department doesn't provide any guidance on that. Could a school have a rule for track and field at all levels? Again, the department doesn't provide much guidance. Could it have a rule for all varsity sports? Again, the department doesn't provide any guidance. Another thing that's very unclear is whether these criteria have to be applied at the sport level or by individual athlete. So the fact that the department says you should consider each sport grade level and competition suggests that the department seems to be allowing rules at that broad level of generality, that a school could have a rule as to track and field at the varsity level. But on the other hand, there are statements that you can't apply any generalizations and you can't rely on administrative convenience, suggests that in application, the department will say, you have to make these decisions on an athlete by athlete basis. And if that is the end result, you can imagine this is going to be extremely difficult for schools to figure out how to follow this rule. And then the last aspect of the rule is that even if a rule limiting a sport based on biological sex would meet the first half of the test, it also has to minimize harm to transgender students. So what does that mean? Again, the department provides very little guidance about what that means. And it lists only two types of harms that it says schools must minimize. The first is the harms of having to document a person's biological sex. So if a school district has a rule, limiting track and field, for example, based on biological sex, it needs some way for its athletes to document what their biological sex is, if there's any question, although there's often not. The department says that itself can harm transgender students, and so schools must minimize that sort of documentary harm. But of course, it's totally unclear what that means, because you have to require some sort of documentation. And then the second harm that schools must minimize is the harm of having to play on a team that is inconsistent with the student's gender identity. So you can see if that is one of the harms that has to be minimized, that could end up swallowed, and the department doesn't provide any more about what they mean about this or how schools can minimize that harm. So the bottom line here is that the new athletics rule provides very little clarity to school districts and colleges. It places a lot of power in the Department of Education to decide on a case-by-case basis what it thinks is allowed and what isn't. It's going to require a lot of litigation and argumentation before the department in enforcement actions, before schools have clarity about what types of rules the department thinks are allowed and what aren't. And it's going to be very costly to schools to have to mount a case and mount evidence in order to defend any rule. And so what is going to probably end up happening is a lot of schools will just give up and not even try, and will simply pass broad rules allowing any transgender student to play on any team they want associated with their gender identity, which is likely what a lot of schools will end up doing. And is probably what the department intended by passing this rule, to make it very difficult for schools to limit sports based on biological sex. This could change in the final rule. The department asked a series of directed questions to commenters. Can you think of any other good reasons why you might limit sports based on biological sex? And should we include some of this in the regulatory text? So a lot of the guidance that I've discussed could be in the text of the final rule. But we're just going to have to wait and see what the department does in October. And whatever they do, it's very likely that the rule will be challenged. And it could take a while of litigation before we know the outcome of the rule. So I'll stop there, and then we can take some questions. Again, as Cory mentioned, put your questions in the Q&A, and we will look through them and answer them.
I don't see any right now, but there were two things that I kind of wanted to flag because I believe we have some leaders. Oh, here comes a question. We'll get to this. One thing I wanted to flag is that if you are part of a private religious school or a leader of a religious school, to know that private religious schools that receive federal financial assistance are generally subject to Title IX requirements, but importantly, an educational institution controlled by a religious organization is exempt from Title IX to the extent that compliance would not be consistent with the religious tenets of the organization. So just there's more detail we could go into there, but just kind of to mention that. And then even at public schools, another critique that has been raised about these proposed rules are, if students are compelled to go against their sincerely held religious beliefs, an argument could be made that the government is infringing on an individual's right to freely practice their religion. So just a few other things on the horizon in that regard.
Cory, I can answer the first couple questions. So one of the first questions that came up is whether a gender neutral bathroom would be sufficient. Under my read of the new rule, no, that would not be sufficient. The new rule is not the model of clarity. If you look at it, you're not going to find text that directly addresses bathrooms, but the way they deal with this is they say you must, in any of our rules that allow for sex segregation, so there's that specific rule that allows for sex segregated bathrooms. So in any of those contexts, you schools must minimize harm to transgender students. Oh, and by the way, not allowing transgender students to use the bathroom that corresponds to their gender identity does not minimize harm, causes more than de minimis harm. So the combination of those two sentences basically means automatically schools must allow students to use whatever bathroom and locker room corresponds to their gender identity. So providing a third neutral alternative, I think under the new rule would not be sufficient. It's less clear under the existing rule. So that is a subject of debate, I think, in the case law. In the Seventh Circuit case, the Kenosha School District had provided a neutral alternative, as I mentioned, and the court in that case didn't think that was sufficient. But one of the things it highlighted was that the neutral alternative was hard to reach. It was all the way across the school. So the outcome could be very different in a case where the neutral alternative is reasonably accessible under the current rule. So again, it's going to depend on whether the new rule survives challenges to it.
Yeah, and to that point, I would just add, we've been hearing a lot from school board members and other individuals that they're being pressured to change their school policies now, whether it be by, media or district legal counsel. And I think there's obviously, as we've been through, there's a lot to follow here, whether it's case law under the existing rule, when the new rule becomes final, what will it say? Litigation once the new rule becomes final. And then just to emphasize, it's not final yet. As Luke mentioned, the department already kind of has issued guidance that it interprets sex discrimination to include discrimination on the basis of gender identity. So that doesn't foreclose that it might open a civil rights investigation, try to ensure compliance, and then absolute worst case scenario, a loss of federal funding. But there's a lot of things to follow here and consider and be aware of, something we're tracking very closely and we want to just put on your radar as well.
The next question is, will this affect club sports, the sports rule? Yes, it does affect club sports. I think it applies to all athletics that a school or school district has. And I think I covered this, but under the new rule, the department says basically anything but varsity sports, it thinks in its guidance, you wouldn't be able to meet its balancing test because competition and risk of injury are not as significant or important of objectives in those contexts. So I would think club sports, it would be, at least according to the department's interpretation of how its tests apply, it would be very difficult for a school district to defend a rule limiting club sports based on biological sex. But again, all of this is going to have to be litigated because none of this is spelled out clearly in the text of the rule. It just applies this ambiguous test and then provides guidance on how it thinks that test would come out in different contexts.
I'll kind of jump around a little bit here. One attendee asked if you'll be able to share a recording of this. And yes, it is being recorded. It will be posted and shared publicly if anyone would like to share it or rewatch later. I also wanted to kind of preview, Luke and I, along with some of our colleagues, are going to be working on a more detailed memo kind of the litigation landscape. So that's some research we're doing as well. And again, this will be posted publicly as a public resource. One question, can a school district hold a public forum to inform parents what is under consideration? I think that's a great idea. Any increased transparency and parental involvement, community involvement, generally, I think is a really good idea. And it's honestly good for kids in the district. And, as a school board, as district administrators, you ultimately want to educate your students. You want to kind of highlight academic excellence, and holding a public forum, increasing transparency to talk about these things is, I think, would be a good idea at the local level. And obviously, considering everything we talked about, deciding what is under consideration at the local level is really important as well.
There's a follow-up question to the club sports question that I just answered. I think that the questioner was asking not so much about club sports at a college, but about private clubs outside of a school district. So probably not. Title IX only applies to the education context and to educational units that receive federal funding from a variety of sources. So I without knowing any details, I would assume that a private club likely wouldn't be covered by Title IX. And so the rule wouldn't apply to
that. One attendee asked kind of about the comparison of the rights of a transgender student versus the rights of women and girls. And I think that it's a really relevant question. Some of the policies that we've seen both in Wisconsin and around the country indicate that in single spaces, such as locker rooms, if it's a girls' locker room, if the girls are uncomfortable or if they desire more privacy, then it is the girls that are told under these school policies. And the ones that we've seen, it's not clear if they're board approved or just something that the administration has put in place, but it's the girls that are asked to leave. And I think it's really important consideration to make when you're putting these policies in place, considering the legal landscape, how can we respect all students and, importantly, protect the privacy and safety of our girls at the same time? And unfortunately, the way that these proposed rules are published and the text currently in place, in my opinion, doesn't address that, and it doesn't adequately do that.
Yeah, and to that point, I mean, the argument that this is going to harm women and girls and interfere with their privacy in locker rooms and bathrooms is going to be a main focus of the litigation and the challenge to this rule. And I think if the challenges are successful, that's going to be a huge part of it. I mean, the one thing, the reason that sex under the Constitution is subject to intermediate scrutiny. Intermediate means between two other levels of scrutiny. I'm getting into the weeds a little bit, but some types of discrimination, race discrimination, are subject to strict scrutiny. Generic, non-protected classes are subject to rational basis. Sex discrimination is intermediate, and the reason it's intermediate is courts have said there are good reasons to separate based on sex. And one of those good reasons is to provide privacy. And so the bathroom issue particularly has, until recently, been sort of the main example as to why it's an intermediate level scrutiny that can be met under some circumstances. And the 11th Circuit in its decision said, outlined a lot of those cases, outlined a lot of those quotes, and pointed out that, until recently, everybody has accepted that it's totally appropriate to separate facilities based on sex. And it's interesting, the department is trying to, on the one hand, preserve that line. It's not saying that school districts have to do away with segregated bathrooms entirely, but at the same time, it says that any student can use the bathroom associated with their gender identity, their asserted gender identity. And the problem, of course, is that gender identity is purely the subjective assertion of the person. So any person who chooses to assert that can then use the opposite sex space, and that's obviously problematic for women and girls especially. And so I think that's going to be a focus of the litigation, and we'll just have to see where the courts come out on that question.
Yeah, and to that same point, someone asked if the rule defines a transgender or a transgender student, and I'm not aware that it does. And this is a concern that some individuals have raised. Gender dysphoria is certainly real, but the rule doesn't go into any detail about how a school is supposed to make that determination and allow access based on gender identity. It's kind of just that they must comply or allow based on a student's asserted gender identity. I know individuals have asked about, what if a student is gender fluid? What if, does it matter if they've started to transition socially, medically? And I don't think that the rule addresses those questions. And one thing I wanted to flag too, someone asked, how do we know how much federal funding our district is receiving? So Will has a school scorecard for those of you who aren't familiar. It uses data from the Department of Public Instruction. It's at knowmyschoolwi.com. And it has things such as, English and math proficiency and other data, but part of it is also per pupil spending and how much of that spending is federal versus state versus local. So that's at knowmyschoolwi.org. I think we have some attendees on here that aren't from Wisconsin, but if you are in Wisconsin, you can kind of use a drop down, go to what your school district is, and all of that. It's from data from DPI. We've kind of tried to put it in one place to make it a little bit easier to access.
One of the earlier questions somebody asked was, can you clarify the differences between elementary schools and middle or high schools? So with respect to the bathroom issue, I don't think the new rule draws any distinction there whatsoever. So if the new rule is finalized as written and it survives the litigation challenges to it, it will mean at all levels, elementary, middle, and high school, schools will have to allow students to use bathrooms and locker rooms consistent with their gender identity rather than their biological sex. On the sports issue, the text of the rule itself doesn't distinguish between elementary, middle, or high school, but the department's guidance says we think this would apply differently at those levels, and actually, interestingly, requires sports to allow students to participate based on gender identity at elementary and middle levels, but at high school levels where there's higher levels of competition, the department says, well, more likely at those levels that schools would be able to limit sports based on biological sex. So there is a difference with the sports rule, but only in the department's guidance.
I think one last thing, and we've touched on this briefly, but I'll expand since we have a little bit of time left, is just, what about the harm, quote unquote harm, caused to girls by having a boy in the girls' locker room? And obviously, we think it's important that girls' privacy and safety in their locker rooms and bathrooms is respected. All students should be respected. And one thing here is kind of the sexual harassment standard. It includes behavior that's a reasonable person would determine to be severe, pervasive, and objectively offensive. So, you know, if an individual, if a boy, if a male student is exposing himself to girls, for instance, in a locker room, in a shower area, then, you know, there could be an argument that that might meet the definition of sexual harassment. It could impact those girls when, you know, they thought they had their privacy, their safety, and now they have to go to class, and this was unwelcome conduct based on sex. So there is that kind of conflict between the proposed rule and allowing access based on gender identity, period, and then also protecting the girls in their single sex spaces, which is also a requirement under the rule. So it's kind of just another indication that these rules, I think we're going to see a lot play out in the court system in the coming months.
Well, I think we'll stop it there. Thank you all for attending. I think we still have the slide up with our email addresses, so feel free to reach out to us afterwards if you have any questions or want to discuss anything related to this. We're here as a resource and just want to be a help on these topics.